Hi, I'm Bill Powers, and I am answering questions on public message boards from people probably very much like you. They're asking general questions. Sometimes they ask more specific questions. For the record, I would encourage you to not post too many specifics of the case. I've actually seen cases or questions online where the person admits to a felony that could put you in prison for the rest of your life. So I would encourage you online to remember that other people besides lawyers may be reading the questions, and not to put anything overly specific or personal on the question. And there's a reason why we offer free confidential consultations, because we want people to call us up and feel free to ask and give us all the information so that we can give an intelligent, smart answer, not smart alecky answer, but a smart, well-reasoned answer to you based on the facts and the law of your particular case. All right, so here we go, and I'm going to paraphrase this particular question. It says, how much to get my case recalled? I know right off the bat that is probably someone not from North Carolina. We see that term used in other states. I missed court, it's about the same month. It's relatively close to when they posted a question. I had two different court dates. When I asked about future court dates, I had a feeling I'd miss court. It seems like it's an incomplete question, but it seems like they were worried about missing court and indeed did miss court. And now the bond was a good amount of money, and it's been doubled, and I need to get it recalled. Recalling is a term, and not to be obtuse, I think most people are referring to, can I get the legal process of an order for arrest or an order of forfeiture set aside, or have the judge recall that order. It may be a matter of semantics, but we would normally refer to that as striking an order for arrest, or striking an order of forfeiture, or setting aside. And there are times that that's possible with your attendance, and there's times it's not possible where you actually have to come into court. And there are times where they will not recall, if you want to use your term, that, and you actually get arrested and have to post that bond again. It's not unusual to go into court. We see these things where they call the name out. It kind of comes from the old common law. You actually hear the officers, the judge will say, call them out, and they'll say, hear ye, hear ye, hear ye, or they'll have the person's name, Bill Powers, Bill Powers, Bill Powers, come as you're bound to do, or an order for arrest will be issued against you, and order of forfeiture of your bond will be ordered. And I'm, again, paraphrasing it. They say it a whole lot nicer than I do. They read it from a little card. And then I hear the judge say, double the bond. Or they talk to the clerk and they say, how much is the bond? And they consider, and they say, set a secured bond, cash only bond, if someone's been bad about coming to court. So with the bond that was listed in this particular case, it was high enough that I would think it would probably be a felony. Felonies are more serious. Felonies are a little bit more difficult to handle in court. You may be dealing with a superior court judge as opposed to a district court judge. And so there isn't an answer specifically, what should I do other than this? Call a lawyer. It's time to get a lawyer involved. It's time to realize that the system is not always easy to navigate. In fact, sometimes the system's not just downright not fair. And it may be a matter of just calling a district attorney's office, having a consent order drawn up, and striking an order for arrest and order for forfeiture. It may require adding the matter back onto a docket and bringing you there and explaining to the judge why you weren't there. Give us a call. The consultation's free. Telephone number is 704-342-HELP. Good inquiry, and hope to hear from you.